Yes, please.
Item number 1 to 5.
Yes, sir. Please.
My lord, we have filed an application, my lord, cutting down the witnesses list before the trial court, my lord. I'm supplying copy, my lord.
Yes. Is it listed before us?
My lord.
Listed? Is it listed before us?
Well, this application has been moved by them before the learned trial court as per my lord's direction to reduce the number of witnesses. So they have reduced it by 317. So this is a copy of that application.
So, my lord, your lordship recollects, my lord, initially there was a long list of 400 of some witnesses, my lord. And on last occasion, I submitted the CBI is proposing to cut down the list of witnesses. And lordship has directed us by last order to file an application before the trial court indicating the proposal to cut down the list, my lord. So pursuant to that, we filed an application, my lord, reducing the number by 317. In para 5, your lordship kindly sees, my lord. Decided to drop 317 numbers of prosecution witnesses as listed in the separate sheet as an with. And then, my lord, the CBI proposed to add 6 witnesses.
Has this application been considered?
Yes, my lord. It was listed today and the application has been allowed and the matter is next fixed for trial from 5th of May to 9th of May. As per my lord's direction that once they give us a copy of the number of witnesses, then the trial can proceed.
And in the meantime, we will consider this application.
Well, the trial may proceed, my lord. In the meantime, the lords with the 482 question petitions may be heard.
No, because the point which has been raised is that if the charge is devoid of any particulars, then the accused is liable to be discharged. And if the accused is liable to be discharged, there is no question of examination of witnesses, the trial to continue. So that has to be decided first. Because there are 2 stages. One is the discharge stage, and the second is the acquittal stage.
So, my lord, in fact, the applicant, they filed an application for discharge before the trial court, my lord. That was heard and a very detailed order has been passed. Against that order, they come up with this order. The discharge application under section 227 was considered by the trial.
And what was the order?
Order was that there is sufficient material to frame
This
the
is
charges.
impugned order, my lord, against which we have come.
Then why you have preferred an appeal from that?
Well, we have not preferred.
In our appeal, the first item in the cause list is actually their challenge against an order in our favor, whereby we have deferred, we have got the cross-examination of certain witnesses deferred because they are going to submit on the same set of facts. So we want the examination, cross-examination to happen together of those 5 witnesses. Therefore, it has been deferred. They have come against that order. That's item number 1 before my lord's today. And item number 2 is against the charges. And 3 is again against a severance order. So if my lord can hear item number 2, and if it's decided in our favor, then the rest of the matters may not be heard.
That is quashing.
Well, item number 2.
Yes, please take them. both learned counsel have relied upon an application made by the prosecution before the learned court, before the court of the learned special judge, bracket CBI at Shillong. In the criminal proceeding in question, special case number 2 of 2020.
This page is correct. They are correct.
Further to my order dated 22nd February 2025. Observing that the large number of witnesses proposed to be produced for the prosecution be suitably curtailed for a fair trial and for the ends of justice. Full stop. Of course, it goes without saying that such curtailment of witnesses would in no way sacrifice the sufficiency of proof to be adduced in this kind of a matter. Paragraph. In this application, in paragraph 5, the prosecution has decided to drop 317 of their witnesses. How many witnesses were there initially?
492.
492.
317 out of 492 witnesses, and to add 6 additional witnesses. Paragraph, we are told that this application has been allowed by the learned trial judge. Paragraph. Earlier, 20 witnesses have been examined.
28 witnesses.
28 witnesses have already been examined. Next, the next date of trial is 6th May.
5th of May, madam.
Is 5th May 2025. Paragraph. In the circumstances, the trial is now ready to proceed. Paragraph. Nevertheless, there are pending applications before this court, the foremost being an application by the accused under section 482 of the Criminal Procedure Code to quash the criminal proceedings. We have started hearing this application. Full stop. If this application succeeds, then that would be the end of the trial. Full stop. If it does not, the trial may continue. Paragraph. In my view, there is no point in further continuance of the trial at this stage before disposal of this Section 482 application. However, we are not formally staying the trial. This court is not formally staying the trial, but only requesting the learned Special Judge bracket CBI at Shillong to adjourn further examination of witnesses for such period as he deems fit and proper to enable this court to conclude hearing of the pending applications and to pronounce a judgment. Paragraph. Learned Mr. Salman Khurshid, learned senior advocate, appearing for the accused in the Section 482, is requested to continue his arguments in the Section 482 application. You can start.
Deeply grateful, my lord. Deeply grateful, my lords. I'm grateful your lordships accommodated me for one day where I wasn't available, my lords. I expressed my gratitude. My lords, I gave a short background of the matter on the last hearing. If I may just take a minute to...
The numbers were changed. The marks were changed by interpolating in white ink.
Quite right.
By it,
I'm obliged, my lords.
the question is whether
My lords,
accused. The question is whether the accused did it or she aided, abetted it, or in any way collaborated in its erasure. That detail is not there in the argument.
Greatly obliged, my lords. May I just trouble your lordships with 1 minute on the backdrop. On the backdrop is your lordships are familiar how the High Court had intervened, how the matter was transferred to CBI, then a high-powered committee was set up, etc. We're not concerned with that. Concerned only with the investigation that was done by the CBI into the culpability of accused one that I'm representing, accused two, the director who was responsible for the secretarial work that was done in the selection of candidates, and the lists were drawn up, and accused three, whose trial has been severed from this trial because of medical condition. So, my lords, essentially, it's the culpability, if at all, of accused number one, who was then the Minister for Education, which is before your lordships in the challenge, in the impugned order that is before your lordships, the order on charges. Now, my lords, there are two important points in view of what your lordships have just observed. There are two important points. My lords, one is the extent to which the charge sheet and the order on charge is able to establish that there was wrongdoing on behalf of accused number one. Well, that's important. There has to be sufficient material in order to come to a conclusion from the trial court. This is a matter of sufficient suspicion or grave suspicion, and therefore charges should be framed. Well, the second point that arises is whether in the totality of circumstances and the facts as accepted for the purposes of framing of charge, whether on the law a case can be made out or not under section 420 of cheating or under the section of 468 of forgery. My lords, that I would
Please.
So, my lords, if I may just request your lordships to consider. If I may just consider request your lordships to consider 2 or 3 important points that emerge from the charge sheet and the order on charge. If I may just take your lordships very briefly to the order on charge. My lords, your lordship will find this in the petition at page 66. The charges are framed at page 66, but to give a backdrop, if your lordship will go to page 44, annexure 1. Your lordships have annexure 1 at page 44. And this is the order dated 23rd of August 2022. As I take your lordships through this order, if I may briefly point out, well, it's the procedure for selection. If your lordships will just keep that in mind. Well, it's the procedure for selection.
Yes.
Began with the selection committee. The selection committee interviewed all the candidates, and each member of the selection committee marked the candidate on various parameters. We are not concerned with what the parameters were, but the marks were given by individual members of the selection committee. These are the score sheets. The lordships will see those. These are the score sheets of marks given by individual members of the selection committee. And they were signed. All these score sheets were signed by the members. Thereafter, my lords, the different members had given marks in the score sheets. Those marks were consolidated, collated, and consolidated, and a consolidated mark sheet was drawn up. Well, it's from the consolidated mark sheet. In the consolidated mark sheet, the merit list was prepared. The merit list was prepared. A cutoff was taken of 40 marks or 39 marks, as it may be, and a merit list was prepared.
Yes.
So your lordship will just keep this in mind. There are very significant gaps that I will point out to your lordships as we proceed. But if your lordship will just please first look at the order on charge. And my lords, if your lordships would be briefly look at the prosecution argument, which is at page 48. Well, as the case made out against me, your lordships will find in paragraph 12.2. If I may read that to your lordship, learned prosecutor submits that material collected during investigation divulges that original merit list was destroyed and new merit list was prepared under the signatures of A2, that is the person who was responsible for drawing up the papers, after manipulating the marks of the original score sheets. Further, the prosecutor submits that there is sufficient evidence to show that these manipulations were made at the behest of A1, my lords, A1, the accused that I represent before your lordships, who had approved the final list of the selected candidates. A1 has played an important role in manipulating the original score sheets and destruction of the original merit list. Now, my lords, this is the heart of the charge against me, and the heart of the charge against me is not substantiated by any of the things that the charge sheet says, the order on charge says, and the charge sheet say later. So if your lordship will see here on this very page 48, the prosecutor has drawn attention to this court to annexure 8, annexure 7 of the charge sheet, to manifest the 69 candidates out of 100 candidates recommended by so-and-so and so-and-so and so-and-so. Well, the accusation is that public figures, that public persons made recommendations, and those recommendations were then finally transmitted to the person who is said to have interfered with the list. Then, my lords, if your lordships would be good enough to come to page 49. Page 49, 12.3 speaks of connivance with accused A1 and A2. So I'm accused of connivance. 12.5 talks about 2 lists of candidates given to A2. Well, if I may just say so, none of this is substantiated anywhere, but we'll come to that in a moment, my lords. Then, my lords, at page 50, at page 50, paragraph 12.6, the prosecutor submits that there is sufficient evidence on record to show that A1 received recommendation letters from public representatives. A1 shortlisted the candidates and directed A2 to select them. The materials on record reveal that A1 and A2 had entered into a criminal conspiracy for manipulating, forging the original score sheets, etc. And then ultimately, at the bottom of that paragraph, the list was approved by A1 in great haste. My lords, in great haste, being as though approving something in great haste is something to be charged independently. Then, my lords, on page 52, the arguments that are made on behalf of A1, and then page 55, arguments on behalf of A2. Your lordships will be good enough to come to the decision that begins on page 57, paragraph 15. Your lordship will see here my first important point that the learned trial court failed to take into account, my lords, is paragraph 15.6. My lords, that's the charge on forgery, and we had argued on the basis of Sheila Sebastian, which is 2018 7 SCC. My lords, in the compilation we've given, your lordships will find Sheila Sebastian as well. But right now, I'm just taking your lordship through how the trial court has dealt with Sheila Sebastian. If I may read 15.6. Senior counsel for A1, apart from the argument advanced narrated above, has also raised a question with regard to the offence of forgery, taking aid of Sheila Sebastian, where it was held that the person actually committing forgery can be the accused of the crime. The person actually committing forgery can be the accused of the crime. The decision in Sheila Sebastian was arrived after trial on appreciating the evidence adduced during the course of trial. In the case at hand, the materials on record are scrutinized for the purposes of framing the charge. The court has to form an opinion on the material on record if presumption can be drawn for an offence. In other words, the question is here, we are not going into facts. The facts as found for the purposes of the order on charge, those facts are not being questioned because those are not the facts that we can question. We are not putting up a defense as far as facts are concerned. But the law is very clear that you can't accuse somebody of forgery who hasn't physically done the forgery. The person who does the physical forgery is the person who can be charged. Another person cannot be charged. And what has happened here is the learned judge has said, well, this matter was decided after the trial. Here we are only looking at the charge. The law doesn't change, my lords, for whether it is at the stage of order on charge or whether it is in the stage of the final conviction order and trial. The law remains the same. In other words, this was a very important factor that we brought before the learned judge, but this was not taken up by the learned judge. And I believe this was completely a mistake that was made by the learned judge. So I place that before your lordship. Then, my lords, your lordship will be good enough. Your lordship will be good enough to come to page 62. Paragraph 15.16. The senior counsel for A1 has advanced the argument distancing A1 from the material on record on the ground that there is no evidence to show that the entire alleged manipulation was under the influence of A1. The evidence on record points towards the board members in A2 and further advanced argument on the merit of the matter, stating that A1 cannot be roped in for forgery unless there is an evidence that she is the author of the forgery. The argument for A1 on the point that the allegation against A1 is not of tampering the score sheets, but it has been alleged that cheats, slips, notes under handwriting of A1 were found in the possession of A2, and the same cannot form the basis for framing of charge. But the fact remains that there is prima facie evidence that cheat and note are in the handwriting of A1. It was allegedly recovered from the possession of A2, and the same has nexus with the alleged manipulation of the score sheets. So, my lords, here the main argument on law that the forgery was not done by A1, that's not being questioned. The facts are not being questioned. The law is being overlooked, and that's why we have come to your lordships on this particular issue. And my lords, this is all that there is. Your lordship will see at page 63. That's an important factor. Middle of page 63, paragraph 15.18. Your lordship will see middle of paragraph 15.18. Further, if your lordship have that, in the middle of paragraph 15.18, further public representatives who were involved in recommending the names of the candidates have been exonerated. A1 being a public servant cannot be isolated and fastened with the criminal liability as stated above. These arguments are on the merits of the matter, perhaps may constitute a defense of the accused persons, which cannot be the ground for discharge. But it's the ground of discharge is there something unlawful being done on behalf of the public representatives who made recommendations, and those recommendations have been passed on by the minister, who again is a public representative, but there is no evidence whatsoever that she coerced, directed, or insisted that those matters be taken up in order to help the candidates who had been recommended by public representatives. In other words, that is the sum total. That's the sum total of the allegation against her, that she wrote out slips and she gave them to A2, and A2 then acted upon. Well, that's fine. That's an allegation. Your lordships may come to the conclusion that this is a matter for trial. Let it come before the honourable judge for trial, and then it could be made out. But can it be said, my lords, at this stage I ask myself, can it be said that there is grave suspicion, and that grave suspicion is sufficient to proceed to the framing of charge? And here at page 64, if your lordship will look at paragraph 15.21. Incriminating materials were recovered from the residence of A2, connecting A1, which has strong bearing in the instant case. In other words, what was recovered were slips of paper. But that the slips of paper automatically amounted to her imposing her will on A2 is the big question. And this is where I would want your lordships briefly to look at the charge sheet. There are a few passages in the charge sheet that indicate the situation to be quite different, but have been taken up in the order on charges in the manner in which I read this to your lordships. Your lordship will come to the charge sheet. My lords, that charge sheet begins at page 87. This is lecture 3 at page 87. Your lordships have charge sheet at page 87.
Yes.
Your lordships would be good enough to come to the bottom of page 100. So this would be very important as I show the lordship the documents that were in front of the Honourable Trial Court. Last 4 or 5 lines, my lords, at page 100, internal page 13, paragraph 17.17. Last 5 lines, my lords. It has also been revealed that at the end of the day, the member secretary had collected the score sheets of other members of the interview board and compiled the marks awarded by other members in their respective score sheets and prepared a final score sheet. Once the final score sheet was prepared by the member secretary, all board members had signed the score sheets. Your lordship may know that the member secretary collected the score sheets, compiled the score sheets into one consolidated list, and all the members signed it. All the members signed it, my lords. If all the members signed it, then that score sheets, as compiled together, could not possibly be changed, because to change them, not only the marks would have to be changed, but the names that have been put in the score sheets, in the consolidated score sheets, would also need to be changed. And I will just show in a moment, my lords, that has happened at any stage. It'll take only 5 minutes to show to your lordships how that has happened. My lords, your lordship will see page 101. At page 101, the last paragraphs.
Sufficient evidence.
Where, once again, sufficient evidence, grateful, my lord. Sufficient evidence has been collected to prove that the score sheets originally prepared by member secretaries after interviewing the concerned candidates are forged, manipulated, and tampered dishonestly and fraudulently by abusing official position of Srimati Ampreen Lindo A1, Sri J.D. Sangma A2, and Srimati A.I. Lindo A3 by applying white fluid, overwriting, and insertion of marks or the blank cells which were left blank as are not applicable for a particular candidate, which are clearly visible even with naked eye. Investigation is established that all such forgeries, manipulations, and tamperings were done by J.D. Sangma A2 and Srimati Lindo A3 on behest of A1 in order to include the names of candidates recommended to the Education Minister by various public representatives and also her own favorite candidates. So this is the charge. This is the charge that's against me, my lords, that I have imposed my will, and on the recommendations of public representatives, I have suggested that you substitute the names of successful candidates with the names of those that I'm recommending, and that is where the forgery has happened. My lords, now, if I may just show your lordships 3 documents that my learned friend had already placed before your lordship's court. In case they're not there, the lordship will take those 3 documents up. I call them document 1, 2, and 3. Well, this is just to explain how this matter has proceeded. My colleague, my colleague, Ms. Sanjita Ayen, will place the documents before your lordships again, just in case it's difficult to find them. Well, the first is an example of Juwai subdivision. I've taken it entirely from the charge sheet. So your lordship can be assured that no new document is being introduced. This is taken from the charge sheet. So lordship, document 1. This is the Juwai subdivision. There are four columns here, my lords. Your lordship will see the first column has list of candidates who have qualified for appointment. Well, all these candidates in column 1, all these candidates who qualified, your lordships will find in column 2, which is the consolidated score sheet of the results of the interview. So it isn't that any of these candidates have come in from outside. They were not in the consolidated charge sheet, the consolidated score sheet, that they were interpolated and introduced. Your lordship will see from column 1 to column 2, all of these people who are qualified in column 1 were actually in the consolidated score sheets in column 2. Well, the number of the pages I mentioned, the lordship would turn to page 197. Your lordship will find all these same people who figure here. And then if your lordship will see column 3 are the marks of the score sheets, individual score sheets. So the same person's marks in the individual score sheets are put down, and column 4 your lordships will see. Column 4 are the marks that they finally got, which can be compared with column 1 from 45 down to going to 40. So, my lord, there is this is an example from what they have, from what CBI has put in the charge sheet, that they have not shown any evidence of somebody who is today in column 1.
Yes.
Well, CBI has not shown that anyone in column 1 is now in column 1. Well, your lordship will excuse me if your lordships are not feeling very well. If your lordship would
No, it's
want
okay.
to take a break, I don't want to impose myself. All right, I'm
Yes,
grateful. I'm grateful, Mullah. I'm grateful. So, Mullah, all I'm saying is column 1 has people who qualified. Now, there is nothing in the other columns that indicates that somebody who was not in those columns has been included in column 1, and the marks that appear in column 1, which is to be shown in column 4, that those marks were not there, or those marks were later on introduced. But be that as it may, my lords, I just want your lordships to look at one more document, which is document 3, my lords. Lord, I'll concede. Lord, I concede that there is. I concede that there is an allegation that slips were given. Please help this person. Please bring this person up, etc., etc. That slips were given, and that is the main charge against me, that you gave these slips, but nothing more. That the giving of the slips followed with coercive orders, that giving of the slips then followed with definite instructions, etc. And if your lordship have document 3, this is just to show that there is no pattern. There is no pattern which your lordship will find from various pages, etc., that indicates that merely because the minister gave a slip, that person had to succeed. Now here, your lordship will see R.C. Lalu, who was an MLA, and on whose slips various remarks were written by the minister to be listed. Please bring up a total of 37 persons in this category were in the list on the slips that were seized. Only 25 of those had remarks written against them. Out of these, 5 are not part of the list that the CBI has given. And out of those 37, 13 were not selected. 13 were not selected. 1 was selected, though without any tampering, and 6 were selected with tampering. This is the argument. So, there is no pattern. There was no way that a particular person could be treated as requiring tampering. A particular person was not requiring tampering. There is no to and fro communication with the ministers to say, if you can't do this, then you do this one. If you can't do it, then you please leave it out. If your lordship will just go to the bottom of this, where an extra 8 of page 103 has been analyzed, and your lordship will see these are the people at the bottom selected and tampered, but there is no note. There could be some charge that there was tampering in their case, but there is no note. That is the beginning of the argument that because of the note there was tampering. Then, my lords, there are a few on the next page. There are a few, which are 11, that have been selected and have been selected because of tampering and because of the note that followed. So there are some where there is no note, 21 where there is no note, and 11 that there is note. Then, my lords, the next category is where people have been selected without any tampering, without any note. Then, my lords, there is a next category in which there is a note, but there is no tampering.
No, this order, sir, this order at page 44, was it passed in application?
At page 44, my lords?
Yes.
This order was passed on an application for discharge. The learned judge disposed of my application.
This is the improved order here.
Yes, my lords. My lords, all this was before the judge. So the CBI charge sheet was before the judge, and our application for discharge was before the judge. And my lords, my argument was that there has to be a pattern. If the accused, was saying this person needs to be included, then there has to be a pattern of inclusion. It cannot be at random, somebody included, somebody not included. because there was no way, no parameters by which it could be judged, etc., etc. No pattern meant that they may have been, and to that extent, I have to concede before your lordships that not for the trial, but at least at this stage, there is a finding that the slips had her writing on it. The slips had her writing. The impression given that the actual consolidated sheets had her writing, or that the merit list had writing, is completely wrong. And I will show that in a moment, my lords. If your lordship will now proceed from here, if your lordship will proceed on to the next argument that I'm placing, which is, what is the, if your lordship will now please, in reverse order, come to page 194. 194. This is annexure 4. Now, this is the crucial heart of my argument. I'm taking an example, my lords, of July, but I have done the same thing for other places as well. But for July, I'm taking an example, and this would make my argument pithy and I hope persuasive. Your lordship will see at page 194. Your lords, this is at page 194 and 195 is the final merit list that is drawn up. This is the final merit list that is drawn up, and this is signed by the director alone. Number of saying over and over again that the merit list as made out originally was destroyed and a new merit list was placed. Your lordship may keep that in mind, that allegation in mind. This is the merit list that is on record. Now, if your lordships will compare this merit list with page 197, the same names appear on the consolidated list, and the same marks appear on the consolidated list at page 197. Your lordship will see this is next 2-3 pages. It goes up to 150.
It starts from 194.
Well, it starts at 184, 194. 194 is the merit list, the final merit list. Now, if this final merit list has just been pulled out of the air after manipulation and so on, then the proof would be in this merit list itself. But if this merit list is based on the consolidated list, which starts at page 197, then it can't be argued that manipulation has happened unless it is argued that manipulation has happened at page 197, 198, 199 and 200. Well, but that nowhere in the arguments on charge or on the charge sheet has this been argued, that this consolidated list that you find from pages 197 to 203. There is no departure in the merit list that's produced, and the handwritten consolidated list that has been prepared from page 197 to 198. So, my lords, I ask myself this question: where the manipulation has happened? We talk about white ink and so on and so forth, but in the charge sheet, it hasn't been said that this is the stage at which manipulation happened. They've not said that manipulation happened in the merit list. Destroyed, why it was destroyed, and how did this merit list come about? They've not done any explanation. Then
Can
this
we
merit
continue?
list, as it stands before your
Sir, can we continue on the next day?
Manoj, there's no problem, Manoj, as your lordship pleases. Manoj, may I suggest one thing, Manoj? Manoj, the arguments that I'm making, I may be allowed to put them down on a short written submission note so
Yes.
that your lordship would have it. I will do that, Manoj. As your
Yes.
lordship pleases, I will do that, Manoj.
Yes, I'm also taking my notes and
Manoj, I've seen the lordship taking copious notes.
and
Just to help the lordship.
your written submissions would be of much assistance.
I'll do that, Manoj. I'll do that. They may not match your lordship's taking of notes, but I'll do my best.
No, please. We have lot to learn from you, sir.
Manoj, we have so much to learn from the bench, so much to learn. And we are students all our lives because we are learning every day. Manoj,
Yes.
we are learning every day. Grateful, Manoj.
And when would it be convenient for you?
Manoj, if your lordships find it convenient after the 25th, any date your lordships could. Manoj, it depends on your lordship's convenience because your lordships are speaking different.
20 after 25th?
30th, sir.
30th.
20th?
If it can be 28th, no? Any day between 28th to 30th.
Find out any matters between 28th,
Yes, is there?
29th?
Yes, we can keep 29 and 30.
Which matters?
Not what happened.
Huh?
Usual method.
28th also.
28 is some
Which matter better?
contradiction of
Condonation of day.
Which one?
So which day would be convenient for you?
My lord, if it was senior, my lord, it was 5th, 6th, 7th, in that week, my lord, sometime.
5th May.
5th, 6th, 7th, in that particular week, my lord.
Manoj, my learned friend finds it on 7th and 8th, and if it's convenient for the court, Manoj, I'm happy to.
7th and 8th May.
Please, Manoj.
Yes. At 12:30, marked at 12:30. After the revision bench. All right.
My lord.
Be grateful, Manoj.
Yes. Mr. Salman Khurshid continues with his arguments, but does not conclude the same. List these matters. Which date? 7th and 8th.
7th and 8th.
7th and 8th of May. Marked at 12:30 p.m. All after exhaustion of the division bench list, whichever is earlier. Yes.
Indeed.
Sitting in division immediately.
Item number 1.
Don't lose it.
May please.
Yes.
Lordship, this is a writ appeal directed against the judgment of the learned single judge. Briefly, Lordship, what happened is the appellant was appointed in the police department.
Okay, 1 minute. Pass over. Call the second matter.
Number 2.
My lord, this is the students Shillong Law College students matter.
Yes.
We have submitted the paper books already, my lord. And now the order that was passed by my lord was quite detailed, and the law itself is there, my lord, where my lord has very beautifully said that when the rule
About that student.
Yes, the law student, my lord. And he has given the exams, my lord. He has done quite well in the exams, my lord. All grateful to my lord's interventions. So I was just submitting the order that was passed by my lords because
We will hear this next week because it's not very urgent. Huh?
Yes, my lord. Can it be after the week, my lord? Next week is entire holiday. Just one working day is there. After that week.
Yes, you please choose a date.
25th I'll be going out. Either before 25th or after the 5th.
Yes.
After the 6th day.
My lord.
By consent of learned counsel for the parties, we fix this appeal for hearing on 6th May.
6th, my lord.
All right.
Second call, item number 1.
Yes.
Please, lordship. Lordship, briefly, just to give a background, the appellant lordship, he was appointed in the police department in the year 2012 in the post of unarmed LNK. Now, lordship, he had rendered about 8 years of service till the time of his dismissal from service. Dismissal of service, lordship, was on account of non-devotion to duty or misconduct. The reason for the the reason was, lordship, unauthorized absence from duty. Unauthorized absence was for a reason of medical emergency. In as much as, lordship, the appellant was undergoing treatment for certain psychiatric issues here in Civil Hospital, Shillong. Period of absence was about 96 days, lordship. And after the completion of the disciplinary proceedings against him, he was dismissed from service. Pursuant to which, lordship, a statutory appeal was also filed before the appellate authority, which is the Inspector General of Police, and the order of dismissal was upheld. Against those orders, lordship, we had filed a writ petition before the learned single judge on the ground that the absence was not at all willful, but because of compelling circumstance, certain procedural irregularities, as also on the issue of proportionality of punishment, lordship. All the three prayers were rejected and the dismissal order was upheld by the learned single judge, against which we have filed the instant writ appeal, lordship.
How long was the unauthorized absence?
96 days, insofar as this particular violation or misconduct is concerned. 96 days, starting from 14th December 2019 till 18th March 2020. Now, in the meantime, lordship, it appears that certain notices were issued to the appellant to resume duty. Now, these notices were brought on record by the affidavit filed by the respondents before the learned single judge. And on perusal, on very cursory glance of the notice, lordship, it appears that those notices were sent to his original address in Bihar, whereas the appellant was all the while a resident of Shillong, undergoing treatment here in Civil Hospital Shillong, which was known to the
Where is the departmental adjudication?
Lordship. The order is at page 73 of the paper book.
'73.
Oh, I'm sorry, Lordship.
Paper book.
There's some paging. I'll just take a Lordship to that. Lordship, the page is at 59 of the paper book. It's written as -59- on the top. And 73 in the corner is written. This is an order of 12/6/2020, Lordship.
Yes, ground. Yes, the removal is to dismiss, no? Anything below removal? Below removal, anything. What are the grades of punishment?
Lordship starts from censure all the way to dismissal of service.
Yes, and in between that,
Compulsory-
withholding of increments.
Increment is there, and compulsory retirement is also there, which is at a higher degree, but less than removal of from service.
No, highest is dismissal.
Lordship, yes.
Below that, removal.
Below that, removal. Before that is compulsory retirement, and before that is Lordship withholding of increment and promotion. And before that comes admonition and censure and
There is no
leave
discussion
without pay.
between, I'm talking to you,
I'm sorry, Your Lordship.
between December and March. He has given some explanation,
No, Your Lordship.
but there is no consideration of that.
No, Your Lordship. Kindly come to the impugn order passed by the Landed Civil Judge, Your Lordship.
We have seen it.
Lordship, if kindly come to page 5, paragraph 7 of the impugn judgment, Your Lordship. He was there was a medical certificate that the writ appellant was fit to join service on 15/2/2020. Lordship, that medical certificate is at page 110, Your Lordship. Kindly come to page 110. This is not a case of not only of unauthorized but willful absence, Your Lordship. Can you see, Your Lordship?
No, but where is the dealing with that in the DP?
Lordship,
In the inquiry report or by the appellate authority, where is the dealing with that?
Lordship, can you see the
Number one, they say that habitual absentee. Now, habitual absentee, you have not taken any steps before.
Lordship, kindly that has been
This is the first DP and removal.
no, Your Lordship. Kindly come to page 6, para E, Your Lordship. Kindly come to page 6, para E, Your Lordship, of the impugn judgment passed by the Landed Civil Judge, where the deed of absence have been recorded, Your Lordship.
No, learned judge is not the disciplinary authority. Learned judge will also not scrutinize the facts.
Lordship, kindly
You see what your inquiry officer has done.
Lordship, kindly see, Your Lordship. He got the reply notice. He got the show post notice. He did not reply. Your
It's all
Lordship.
right, but you just
He admitted the charges.
We have read everything. Please
He
come to page
admitted the charges, Your Lordship.
83. So Roman 7.
Page.
Roman 7 and 8. Please read.
The inquiry conducted by so-and-so, so-and-so was happening. The inquiry duly conducted inquiry, and after observing all the basic requirement of an inquiry, wherein the petitioner has been offered a fair and reasonable opportunity to defend himself, the inquiry officer has discharged his duty without bias and without vindictiveness, and the legitimate author had conducted himself objectively and dispassionately in dealing with the evidence on report when drawing up the final order, which had been complied with and submitted this report. So-and-so were proved beyond reasonable doubt. So-and-so. I have applied my mind and exhibited the documents on record and found that it was conducted in a free and fair manner, and all opportunity have been given to the appellant to defend himself, and taken to so-and-so for is rejected. The indiscipline conducted cannot be condoned, and the quantum of punishment is not excessive. Hence, I find no reason to interfere with the order of the removal passed by so-and-so, Your Lordship. Yes, Your Lordship.
Where is the discussion? Now, go revert back to page 61. Inquiry officer.
Thus, in view of the above fact and circumstances, and after carefully examining the finding, he was proved the charge framed against that he had willfully remained absent from duty with effect so and so, and thereby that has failed to maintain absolute integrity and devotion of duty, which by itself is an act which is unbecoming of a member of the disciplined force. Moreover, on perusing of the service report, it also can be seen that there is a habitual absentee who has been frequently found to be absent from duty without obtaining prior permission or approval from the company, despite this pay being held up and leave without pay being awarded in several occasions for unauthorized absence from duty, that has not yet improved his misdemeanor, and the same has been articulated in
Unauthorized absence was very deeply settled.
Lordship kindly come
Earlier.
Lordship kindly come to page 6 of the impugned judgment, para 8. A fitbit has been filed, Your Lordship, where the list of absent had been issued, Your Lordship.
Page 6.
Lordship, yes. Paragraph 8 of the impugned judgment. Kindly see, Your Lordship, number 1, 82 days leave without pay for unauthorized absence from duty. Then number 2, award 5 days PD for 2 hours daily for consuming alcohol while on duty. Can you see, Your Lordship? And then 40 days leave without pay for his unauthorized absence from duty with so and so. 10 days leave without pay for his unauthorized absence with so and so. 61 days leave without pay for his unauthorized absence from duty so and so. Departmental proceeding number so and so were drawn up against him for his gross misconduct and of duty by so and so. 343 days leave without pay for remaining unauthorized absent. 15 days leave without pay for an authorized absent. 10 days leave for his unauthorized absent. Then the Lordship can be taught to page 8, Your Lordship. 189 days leave without pay for his unauthorized absence. Departmental proceeding was drawn up against him for his gross misconduct and of duty with so and so. Then 96 days without leave for
No, these are not the subject matter of this DP. This DP is 3 months.
Lordship is in the present.
He has been diagnosed with psychiatric illness, mental illness, intoxication. You give him one last chance.
Kindly come to page
Don't
1.
give him one last chance, don't remove him from service.
Lordship, kindly, Lordship, he is a member of the discipline force, Your Lordship. His conduct is very bad. Lordship, in
You
fact,
know how disciplined your forces are, members of the force.
Lordship, in fact, Your Lordship, in one of your similar cases, Your Lordship, recently, Your Lordship, the division bench of this honorable court, Your Lordship.
We are saying you inflict any punishment except removal from service, which is very drastic.
Lordship, in my humble and respectful
Then
submission,
you go before the Supreme Court and
Lordship, in my humble and respectful submission, Your Lordship, the impugned order passed by the land single judge, Your Lordship, need not.
we are not interfering. We are only on the proportionality.
As I have submitted, Your Lordship, he was a member of the discipline force.
Very good. We are not interfering with the findings. We are only on the proportionality. It's a question of somebody's bread and butter. All right, we are minded to give him one last chance. He has undergone psychiatric treatment, detoxification, etc. Thereafter, if he misbehaves, you dismiss.
Lordship, can you see, Your Lordship, there was a medical certificate, Your Lordship, stating that he was fit to join service. Still, he did not join his duty, Your Lordship. Lordship, kindly, the judgment of this honorable court, Your Lordship, in one of the, we similarly with this.
This question of proportionality, where we have our discussion. All right?
Lordship, in this case also, in which I have cited also, Your Lordship, is a case of unauthorized absence, Your Lordship, where this honorable court was pleased to uphold the action of the state to dismiss the person, Your Lordship, from service.
Dismissal is a very harsh
It's
remedy.
true, Your Lordship. It's true. There is no quarrel with
3
that,
months
Your Lordship.
unauthorized absence, this and that.
Lordship, will kindly see the.
He has been in hospital.
Can you see?
He has undergone mental treatment. Let us know.
There was a medical certificate, Your Lordship, that yes, he is fit to join the duty. Still, he did not, Your Lordship. Still, he did not. So that shows, Your Lordship, his.
Many people are specified in treatment. Still, they do not join duty, but nothing happens to them. Please take it up. we have gone through the impugned judgment and order dated 13th April 2023, passed by a learned single judge of this court, dismissing the writ petition. Full stop. The learned judge is absolutely right in observing and holding that the writ court will not appraise the evidence in a departmental proceedings as a court of appeal. Full stop. Very rightly, His Lordship did not interfere with the findings arrived at by the inquiry officer and by the appellate authority. Full stop. But we have a point to make. Full stop. It is with regard to the proportionality of punishment. The appellant has been removed from service. Paragraph. Admittedly, during the material period, he was hospitalized, undergoing psychiatric treatment coupled with treatment for detoxification, so as to cure him from alcohol dependence. As pointed out by learned counsel for the respondent, that no, it is also pointed out by learned counsel for the respondent that in spite of obtaining a medical fitness certificate, he did not join duty. Paragraph. Although both the adjudicating authorities have narrated the facts and have also enumerated the evidence before them, we find that there is insufficient analysis of the evidence preceding the finding. Next, the first adjudicating authority, being the commandant, has held and observed as follows. Page 61, marked in red. The appellate authority, the commandant in his order dated
Twelfth June, Lords.
12 June 2020. Then the appellate authority in his order dated has held as follows. Page 83. Order dated 15 February 2021. 7 and 8. Page 83. Paragraph. On the basis of this kind of an analysis and inquiry into the alleged misconduct of the appellant, the punishment of removal from service appears to us a little disproportionate. Paragraph. We have considered the types of punishment that can be inflicted on a delinquent. We dispose of this appeal by substantially affirming the impugned judgment and order of the learned single judge, but directing the appellate authority, the Deputy Inspector General of Police, bracket TAP Meghalaya Shillong, to substitute as punishment any punishment apart from dismissal from service, removal from service, or compulsory retirement. This order will not immediately reinstate after that date within 4 weeks of communication of this order. This order will operate to reinstate the appellant in service only after the necessary punishment order in terms of our order has been made by the Deputy Inspector General of Police.
Lords.
Job is a very
Lordship, his conduct was very bad, Your Lordship.
He had bad habits. Hope he has overcome those and proceeds. And you please take down. We warn the respondent that in case of future delinquency no leniency shall be shown to him.
Obliged.
Much appreciated.